Oh, that's what you always stinkers. Always do that.
Yeah,
You learn.
I watch what John did.
I see how it goes. Then you get those candid cut-ins. Ever wish you could grab a beer and ask a lawyer any question you wanted and have them break it down for you? Lawsplaining at GRL Law breaks down fancified legal mumbo jumbo over beers so all may understand. All right, well, welcome back. I already opened this. I got a little excited. To this episode of Lawsplaining, I am the only person talking at the camera into the mic for this, Bobby Rehkemper. And this is where we break down fancy legal mumbo jumbo and make it make sense, hopefully, if we do it right. I am absolutely excited about this one. I actually accidentally stumbled on really what is a politically and socially hot topic for this episode of Lawsplaining. It is about as relevant as it can be to everybody today. It is on fire. We got another giant case from the United States Supreme Court that I had to read in my spare time. And I'm going to start with a question, okay? Should social media and big tech be allowed to use their algorithms and or manual editorial functions to promote and or demote content based upon their own personal views? Let me set the stage a little bit. Looking back over our prior Lawsplaining episodes, they are probably the lowest viewed episodes of GRL Law. It is true, according to YouTube. Now, some may say it's because of the content, the host, the delivery, the presentation, and there may be some truth to that. However, we have hit topics such as the Trump presidential ballot ruling. We've talked about social media and the First Amendment multiple times. We talked about the TikTok ban. We have an episode coming up on the Second Amendment and firearms. These all tend to be topics that the tech giants and or social media companies are a little leery of and frown upon. Some could allege that these episodes get buried in the algorithms, so they're not popping up in suggested video content. Just saying, some could suggest that. But with the election approaching, there have been allegations that big tech companies such as Google have manually adjusted or have impacted search results in favor of candidates who their leadership and or employees, their business values tend to favor. One particular uproar came when you couldn't find apparently information on the Trump assassination attempt on a Google search right after it happened. There was some really good discussion on one of my favorite podcasts, the All In podcast, about some of these debates and some of these inconsistencies. This is a real and relevant debate and topic. And it begs the question, can a social media provider utilize their editorial authority to manipulate the visibility and availability of user-posted content? That's fancy words. Let me lawsplain that. Could, say, Facebook lawfully, without violating any laws, intentionally bury posts supporting Trump and cause them not to be displayed in others' feeds because Facebook as an entity may support his political opponent? I'm going to pause right there. Go ahead and light us up with your comments if you have any. I'm curious what the vote is on this. As a starting point, okay, the Bill of Rights, which includes the First Amendment, only protects citizens against what? Remember? Government action, okay? If the government infringement upon those guaranteed rights. Going back to the social media and remember the government employees episode, if someone posts something on my social media page individually that I don't like, I can censor the crap out of it. I can delete it, I can block them, whatever it is, as long as I'm doing that as a private citizen, because I am not a government actor. However, if it's a government account or connected to a government account, I can't edit, I can't delete, I can't censor, because that would be government action that infringes upon somebody's expression of their beliefs, of their their expressive content. The First Amendment only protects against government interference with speech or religion, not somebody else's interference with speech or religion. The other important part to understand with this is that non-government businesses, corporations, entities, the Googles, the Facebooks, the Instagrams, the X, the Twitters, all have First Amendment rights. Chick-fil-A has every right to express their religious views as a corporate entity. We may not like it, we may not agree with it. It's their views to express. They can hand out religious propaganda if they want, speak out on moral issues, support causes that align with their corporate values. I don't know if you know it or not, but Shields, at the sporting goods store, often will play Christian-based praise music over their loudspeakers. Free to do that. Media outlets are also free to engage in editorial discretion to determine what content they publish. This is why and how we end up with different politically leaning media outlets, and nobody can do anything about it. So, what about social media platforms? Currently, and for the last few years, politicians have been getting furious about what they perceive to be social media outlets favoring a certain agenda in their news feed, in their availability of content. And so the politicians do what politicians do and pass laws trying to make those outlets be fairer, more balanced in the availability, so to say, of this content. And that's where we find the recent United States Supreme Court case of Moody versus NetChoice. In this case, Florida and Texas, of course, thankfully not Iowa, passed laws attempting to regulate large social media companies and other internet platforms, trying to limit their ability to engage in content moderation, filtering, prioritization, and labeling of user messages, videos, and other content. The law pretty much attempted to limit a business's ability to edit content. Okay? That is a law impacting an individual and their expressiveness under the First Amendment. So this is government action. Okay? Now we trigger the First Amendment alarm. A trade association whose members included places like Facebook, YouTube, sued these states asking to prevent those laws from going into effect. I'm going to save everybody all the legal nuances and law nerd stuff about facial versus as applied challenges in constitutional claims. But the media company did what is called a facial challenge. That's in essence saying the law as written cannot be applied anywhere, anyhow, in a constitutional manner. Now, because it involves regulation of speech, the court requires that the law be weighed, and they have to look at how it could be constitutionally applied versus how it would be unconstitutionally applied, and whatever outweighs the other is kind of the ruling. Regardless, I'm not going to go into the nitty-gritty details. It's enough to know that really the Supreme Court scolded both the 11th Circuit Court of Appeals, that's Florida, and the 5th Circuit Court of Appeals, Texas, saying, hey, dummies, you did this wrong. You didn't analyze the case correctly. Go back and do it all over again. So technically, the Supreme Court punted the big decisions on this case. However, the super important part of this bajillion pages of opinions was that the Supreme Court took a timeout and took a special opportunity to spank the 5th Circuit Court of Appeals the Texas law, because the Fifth Circuit said that the editing and manipulating of user content and prioritization of social media platform feeds was not speech, and therefore the First Amendment was not implicated. I've never read an opinion where a Supreme Court said they was more direct when they said literally Fifth Circuit was dead wrong in that analysis. And this tells you a little bit about where the court is leaning if the case comes up for more thorough review. The court literally said, and I'm going to read this verbatim, the Fifth Circuit was wrong in concluding that Texas's restriction on the platform's selection, ordering, and labeling of third-party posts do not interfere with expression, i.e. First Amendment rights. The Supreme Court made it pretty darn clear that the First Amendment protects entities that compile and curate other people's speech and develop their own expressive product with that material as a result. In those situations, the entity does have really undisputed First Amendment freedom to compile and edit the submitted speech to best express their own viewpoints. The compiler can exclude whatever messages or viewpoints it most disfavors. They can also promote the viewpoints and messages that they favor the most. It really has been that way forever. Looking back in time, newspapers, okay? They pretend to be fair and objective, right, independent, but they're going to lean one way or the other based upon their editorial decisions. The same is said for broadcast television, right? There's a difference between Fox News and CNN. If you don't believe there's a difference, you're not watching the right programming. It's amazing how their portrayal of different circumstances differs. They're allowed to do that. They've always been allowed to do that. Ultimately, what the Supreme Court made clear is the protections of the First Amendment don't go away simply because we're dealing with social media. There are a lot of dangers. There's a lot of concerns surrounding social media, right or wrong. But the Supreme Court made it really darn clear that you don't get to force social media entities to be balanced, to be fair. We don't get to tell them how they are allowed to express their views. And the Supreme Court made it clear that, quote, whatever the challenges of applying the Constitution to ever-advancing technology, the basic principles of the First Amendment do not vary. It is not, never has been, and can never be the government's job to decide what counts and what is the right balance of private expression or to unbias a social media platform's speech. This is interesting because this is where it really hit home for me. When I started reading this case, I was like, no, I mean, you can make them be a little fair, right? No, you can't. Because as the court pointed out, if the First Amendment did not allow social media platforms to exercise editorial discretion, the platform could not prevent or disfavor what many of us may consider morally reprehensible content via their community standards and guidelines, right? And this is the Supreme Court's list. If the First Amendment did not allow them to edit, they could not prevent or downvote or obscure content that would, for example, support Nazi ideology, advocate for terrorism, espouse racism, Islamophobia, or anti-Semitism, glorify rape or other gender-based violence, encourage teenage suicide and self-injury, discourage use of vaccines, advise phony treatment for diseases, advance false claims of election fraud. That's the Supreme Court's list. So, in context, we can't say that social media must not utilize its editorial discretion on certain contents, but not others. Really, what they're going to probably do is leave it to the marketplace to figure out, hey, do I want to be a part of this social media outlet? Do I want to get my information from this social media outlet, knowing where their leanings may be? Or do I want to choose another social media outlet? Or maybe instead of getting our news and believing everything we read on social media, we do our own due diligence and get the information from as credible of sources as we can before we start believing it and before we start acting on it. Because ultimately, if the government can force that moderation, the government would be allowing content-based or would be forcing content-based regulation. And that is something that the First Amendment has always prohibited. The real moral of this story is just because your message or your viewpoint isn't given equal play does not mean that you get to restrict or somehow balance the scales against the other side of the coin. Be loud, be proud, get your message out any way you can, but it's up to the individuals and to the people and to the entities to balance themselves out. Now, one interesting way that this could have been a little bit more effectively defended is had they not just done the overall as applied, everything's illegal, and gone more specific to a more targeted, for example, the news feed regulation or messaging regulations, that kind of thing. And I'd be curious what would have happened if you put the social media platform leadership under oath and asked them whether or not what they're doing is in essence trying to create an expressive product, whether they're trying to communicate their viewpoints through the compilation and through their algorithms. Because I'm guessing if you put them under oath, they would probably try to deny that, not knowing what the greater implication would be for the First Amendment, because they want to come across as objective. They want to come across as just being a platform for people to express themselves. Obviously, social media has come into developed and grown into way more than just that. So that is the lawsplaining as it relates to whether or not social media can monkey with their algorithms to kind of promote their side of the story. And it's sounding like and it's looking like under this Moody decision that they're going to be well within their right to do that if they want to. That's all I got.
How scary is that?
At first I was like, that's scary. I think it's scarier that our population is so reliant on those platforms for information. I think that's the scariest part. We've gotten lazy, we've gotten complacent, and we believe way too much bullshit right out of the chute because it fits our narrative. That's what scares me the most.